Looks like we are recording. So.
I can see that.
Welcome, everyone. We're glad to have you join us. We're just letting people join us at this point. We'll get started here shortly. Okay, should we get started? All right, welcome everyone. Thank you for joining us. I'm Amy Bello. I'm the Interim Director of International Student Scholar Services. I think I know most of you already, and if I haven't met you, welcome. Nice to meet you. With me today, I have Lana Morozova, who is our International Services Coordinator in ISSS. And she handles a lot of our J1 requests and is also working on H1B requests now too for the Anschutz campus primarily. And we also have Stephen Williams, who is an immigration attorney that we work with from Ogletree Deacons. So we will be facilitating this session for you today, and feel free to ask us questions as we're going through. And Stephen, feel free to kick us off. Thank you.
Thanks, Amy. Just an encouragement to use that Q&A function to ask any questions that you have. The three of us will be working on answering those questions, both in the question and answer portal, as well as we'll highlight a few of those for live answer too. So here's our agenda. We're going to quickly talk about areas of responsibility, who does what, with outside counsel and ISSS, just so you understand what that relationship looks like and what we all can do to help facilitate your international employees' situations and needs. We'll then dive into two major kind of worlds of immigration. One that we'll spend the majority of the time on is non-immigrant options. That's temporary employment-sponsored options. Students, J1 scholars, medical trainees will spend a good amount of time on H1B, since that's one of the most common options available for university employees. Then we'll talk briefly about some other options for people from certain countries or in certain situations. We'll jump into green card processes. So this is what's called immigrant, non-immigrant versus immigrant, and options for employer sponsorship of green cards for employees. Then briefly touch on kind of the university process, your responsibilities as department contacts, some costs, overviews, and then just for kicks, since this is the hot topic of the years, last year and this year, we'll talk briefly about COVID-19 and its impact on immigration and what you can anticipate that way. Just a quick summary there. And then at the end, of course, any questions that you have, but we also encourage you to ask questions as we go. So the areas of responsibility. CU Denver and Anschutz Medical Campus, the ISSS office works with a variety of outside counsel to help facilitate immigration needs. Ogletree Deacons is one of those. So I look forward to, I see that I am currently working with some of you, look forward to working with others of you if the opportunity arises. We co-manage with ISSS employment-sponsored immigration program and needs. So most anything besides F1 and J1 that's sponsored by the university as the sponsor, you'll probably work with outside counsel on. Fs and Js are still handled by the ISSS. We will handle sponsorship case preparation and submission. So we'll work directly with the employee to gather information. We'll work with you to gather the information that's needed. Could range everything from just needing some basic information to working with us on recruitment for a green card process, for example. And then we provide legal advice to the departments and employees as requested by ISSS. ISSS and the Office of International Affairs co-manages the university's employment-sponsored immigration program, working with the departments or employees, right? So we're here as a team working together to provide the needs that you have. So any cases that are involving outside counsel, we definitely want to keep ISSS in the loop, understanding what's going on with those cases, because it's a co-management kind of relationship. And then again, manages students and scholars for admission. So specifically those F1 and J1 students and those J1 scholars, that's really primarily ISSS that you're working with on those, not outside counsel. They also help with travel authorization, employment authorization for students and those scholars. We'll talk a little bit more about that. That's just a brief overview. Amy, anything you'd add to that?
No, I think that's a pretty good summary. I think, yeah, the partnership, the teamwork is definitely really important to ISSS. I think, you know, Lana and I support a lot of the work at the Anschutz campus. And then we have several colleagues who work with our Denver scholars and employees. And so, you know, we are a team of 7 within ISSS, but our large responsibility is with F1 students and J1 students and scholars, as Stephen mentioned. So any employment-based cases we are sending to outside counsel, and that has been, and Stephen has worked on a number of those cases, and that is a great partnership that we have. So yeah, sounds good. Thank you. Mm-hmm.
Well, I think, thanks, Amy. It does work well on the Ogletree side and other outside counsel. You'll usually have an attorney contact as well as paralegal contact. Immigration in the legal world it heavily involves skilled paralegals. So you'll see multiple Ogletree or other outside counsel contacts usually on any one case that you've got going on. So we're going to dive into non-immigrant. Again, 2 worlds of legal immigration in the US. One is non-immigrant visas. This is the F1s, J1s, H1Bs of the world. They're temporary. They usually have a specifically defined period, such as the program of study, or for an H1B, 3 years at a time. They require sponsorship, some form of connection to an institution or employer. So Fs have to have a school, H1s have to have an employer, J1s have to have a sponsor. And there are limitations in terms of these specific visas. H1Bs, generally speaking, have to be working to be maintaining status. F1s have to be studying, etc. So there's more kind of limitations and requirements for them to be maintaining that status. Immigrant visas, once obtained, and they usually kind of run in parallel to the non-immigrant process when we're trying to get a green card. But once you get the green card, it's permanent. They can remain a permanent resident forever. They never have to become a citizen. They don't even technically have to renew their green card, and they still would be considered a permanent resident. It's not tied to a specific employer once they obtain the green card, and really basically unlimited in scope. They don't have to work, they don't have to study. Very similar to a US citizen, except they can't vote. And if they commit major crimes, they can be deported. But otherwise, it's basically the same kind of rights as a US citizen. And there's a lot of different agencies involved here. When you're working with outside counsel, the main agencies you're going to be working with are USCIS. They adjudicate immigration benefits in the United States. For the green card process and for H-1Bs, we also work with DOL down there in the bottom as far as confirming wages that are required and some of the applications that we submit. But you're also likely familiar with working with some of these other agencies. CBP, when people are entering the country, CBP, Customs and Border Protection, are the ones who admit them. ICE has a variety of involvement in the higher education sphere. They have an intimidating reputation in the enforcement side of things. Oftentimes people think of ICE and think, oh, but ICE is also very heavily involved in administrating the Student Exchange Visitor Program. So SEVP is part of ICE. So they are not always a scary entity. They are also there to assist and provide guidance and help make sure everyone is complying and has the information that they need to comply with the requirements. Then Department of State is involved in issuing visa stamps. So if you're trying to have someone come from abroad, they're going to need to get a visa stamp at a US consulate abroad from Department of State before they're able to enter. That just gives you an idea of some of the different agencies at the federal level that we're dealing with here. And immigration is almost always a federal issue. It's not often, there are a few exceptions, but not often heavily impacted by states, differences from state to state. So we're usually working with federal agencies here. So now I'm going to turn it over to Amy and then Lana to talk about students and scholars, and then I will hop back in through the rest of the presentation.
Thank you, Stephen. All right, so we're going to talk a little bit about some of your employees that might be in student status. So F1 students in the United States are able to apply for optional practical training at the end of their degree program. It allows them to work in the US for 12 months after completing the degree. Their work must be related to their major. So the degree program that they've completed, their work has to directly correlate to that. And they will obtain an employment authorization document card. We call it an EAD card. And it looks like this card here on the right of the screen. It does, authorize them for the 1 year. It lists the dates of employment on it. So when you are working with an employee who has just completed a degree in the US, they'll present this EAD card for I-9 purposes. And that's where you can see that they've been authorized for the optional practical training. F1 students can apply for OPT up to 90 days before their program end date. So that's kind of the time frame that they're applying for the authorization to work. And also up to 60 days after their program end date. We see a great deal of fluctuation as far as authorization of OPT, and it literally changes semester by semester for students. So, I think there have been some cases where EAD cards have taken longer than 3 months to be issued. We just want you to be aware of that there's a great deal of fluctuation, and we don't really have any control over it either, and neither does the student. So sometimes we have worked on other visa strategies in cases where the OPT card ends up just taking an extremely long time. So just be aware that we may have to think about other options depending on how quickly you need this person to begin working after they've completed their degree. Okay. So that's optional practical training. There's also the STEM extension of optional practical training. And this students who obtain degrees in the science, technology, engineering, and math fields qualify for an additional 24 months of STEM OPT beyond the 1 year. So they get a total of 3 years of optional practical training. And this is a great benefit to those in the STEM degrees Currently, the STEM degree list is listed at the bottom here. You can actually find it online. There are current discussions within the US Citizenship Act that President Biden is proposing to include the biomedical sciences in this, as well as medicine. Currently, those degrees are not in the STEM list, but many employees that we work with in the research, biomedical sciences, they already qualify for the STEM extension. And we have engineers, we have various folks that have this eligibility. So definitely check with ISSS if you have a question about whether your employee qualifies for the STEM extension. They can apply for the STEM extension of OPT up to 90 days before their initial 12-month OPT period ends. So we always encourage them to do that. And they automatically receive a 180-day extension of OPT as long as they have timely filed prior to their OPT end date. Okay, so even if they don't have the EAD card prior to their OPT end date, they could still work for you for up to 180 days. Now, for employees that you hire on optional practical training, we ask that you send documentation to our office so that we can start an employee record for them. We're looking for, a copy of their I-20, which is their F1 document with the OPT or STEM OPT recommendation on it. We ask for a copy of their EAD card for both OPT and STEM OPT, their passport, their offer letter, and their I-983 form, which you should be working on with them, as well as an actual wage form. So those are the documents that we ask to keep in their file. We start an employee record for them, and then we're able to help track when critical deadlines and dates are coming up for that person, right, for that employee. So we'll help to watch when that 90 days is coming up towards the end of their OPT. We'll also start a conversation with you about when that STEM OPT is ending and when we might need to start considering working on an H-1B for that employee. So that's why we ask for that. Now, also for any international employee, they need to be meeting with international tax at the start of their position, ideally within 30 days of the date of hire. So we want to make sure that that's occurring at the beginning of their employment as well. So one additional thing on this, real quick, Stephen, on the previous slide, is that the I-983 form can be sometimes a little bit confusing to work on with a student who's applying for the STEM extension of OPT. We do have materials that we can provide to help kind of guide that process, okay? Because it is somewhat involved, and it's a training plan basically for the employee, and the supervisor signs off on it. The HR professional often signs off on it as well, so we can help guide you through that if you need assistance. All right. So for J1 students, so within, the immigration system, there's, we have F1 students, we also have J1 students. It's just a different way that they're coming to the United States and completing their degree program. For J1 students, they qualify for 18 months of academic training. They can use that either during the degree program or after the degree program. They can use that time or a combination of it. PhD students actually qualify for an additional 18 months once they've completed their degree program. So that's a total of 36 months that they could use for academic training post-degree completion. And the academic training is similar to the optional practical training. It is for the purpose of, training in their field of study. The J1 students may not exceed the time spent in the full course of study. So if they are a one-year master's student, they would only get 1 year of academic training. So that is a note there. But generally, a lot of our students who do academic training are, they've obtained a PhD. So they would often qualify for that 36 months. If the student is a CU Denver or an Anschutz student, we will actually be administering the academic training for them and working on that entire process for the student. If they're a student from another campus, they would be working with their home institution on that authorization and that process. But again, we can answer questions related to that if the employee has questions. All right, so that's it on the student side. I'm going to turn it over to Lana for J1 scholars.
Thank you, Amy. So the next section that we will be covering is J1 scholars. And again, J1 scholars is another type of work authorization that we can use that is coordinated through ISSS. So no additional filing with USCIS needed. And again, this is really important nowadays since there are such long processing times for a lot of employment authorization cards, or for example, H-1B petitions. So that is something that can be done quite quickly. The first thing that I would like to mention is the goal of the J1 program, which is educational and cultural exchange. So this is really important to keep in mind because this program is administered by the Department of State. And basically the J1 scholar is expected to return home to share their experiences that they had here in the United States. And from there, we have certain restrictions that come with inviting a J1 scholar. For example, the participant must not be a candidate for a tenure track position, which means that we can only use J1 scholars and issue DS 2019 for somebody who is not in a tenure track, who is only in a permanent, who's not in a permanent position. This is really important. And also when we're issuing a DS 2019 for a J1 scholar, we need to make sure that they're not subject to the participation against repeat participation, which means that if somebody already been in the US in the J1 scholar category and they finished their program, there is a 2-year period that they will have to spend in their home country to make sure that this cultural and educational exchange is happening before they will be able to come back and participate in a different J1 program. Commonly used exchange visitor program categories are research scholar, short-term scholar, specialist, and the student intern. These are the categories that University of Colorado, Denver, and Anschutz Medical Campus use the most, with the research scholar being the most popular category among all of those. Thank you, Stephen. The next thing I would like to touch on is the limitation of stay. The research scholar category, we can invite those J1 scholars for a maximum of 5 years, but we don't have to process their documents for 5 years at a time. For example, if you would like to invite a J1 research scholar, we can start and invite them for 1 year, 2 years, 3 years, all the way up to 5-year period. And if we invite them for a shorter period of time, we can then later extend their program. And again, the extension is processed by our office, so there is not like a long waiting period for approval or anything like that. And the short-term scholar, that's a really good category for scholars who are coming for the period of maximum of 6 months because they don't have any kind of limitations on the repeat participation like the research scholar will have. So if somebody's coming for less than 6 months, that's the perfect category to use. Another important thing and the consideration for our J1 program at the University of Colorado is that our program does not allow any kind of direct patient contact or care, meaning no touching of the patients. And if you have a scholar who would like to come and who will have some kind of patient contact, then they have an option of getting a J1 as a medical trainee through ECFMG. And then you will be working with Nancy McKay in the graduate medical education. And she's the training program liaison for the ECFMG. So you will be working with her. The next thing that I would like to emphasize is that the J1 scholar option is really good for postdoctoral fellows and visiting researchers. as it is less expensive, it is less time consuming, less work required in order to get this type of work authorization for our scholars than, let's say, an H-1B. So it's a really great option for temporary positions. The other two things to keep in mind is that for J1 scholars, we will need proof of English proficiency and the proof of adequate funding for the duration of the program that we're requesting. So if we only have funding for 2 years available, then we would want to issue the initial DS 2019 for only 2 years. And then when additional funding becomes available for this scholar, we can extend the program at that time. The one potential downside of the J1 program that I would like to mention is the 212E home residence requirement. And this requirement comes up when the scholar gets funding through the government, the US government or foreign government, or if their skill is on the skill list for a specific country. And there are ways to apply for a waiver of 212E home residence requirement. And there is also a way for the scholar to go to their home country and spend 2 years outside of the US to fulfill this requirement. So it's not something that cannot be taken care of in a different way. However, it's really important to keep in mind if you have a J1 research scholar, for example, and their J1 time getting closer to their maximum of 5 years, and you would like to file, let's say, an H1B on their behalf, they would start to getting ready to make sure that they can take care of that 2-year home residence requirement prior to their, let's say, H1B filing. So we would say that they can contact our office and we will let them know about the next steps there. Thank you. And then I will pass it on to Stephen to walk us through the H1B basics for this presentation.
Thanks, Lana. Please do feel free to ask questions in the Q&A portal. I want to make sure that you are getting to understand the things that you want to understand. We have prepared content, but it's more important that you understand what, clear any questions that you have. If they can be generally applicable questions, that's best. If you have individual questions about specific, particularly ongoing cases, you can reach out to ISSS and the outside counsel you're working with. All right, so the H-1B is a major option if what Lana and Amy talked about are not workable, or if those timeframes are coming to an end. For student work authorization, for example, or research scholars that you want to transition into perhaps a longer term position, H-1B is a great option. The general requirements here are that the position requires a bachelor's or higher degree in a specific field. For almost all university positions, that's not going to be an issue. This is pretty straightforward, particularly faculty positions and research positions. You're going to require at least a bachelor's degree in a specific field. The candidate also has to possess the required education. So if they're an expert scientific researcher, but their degree is in computer science and they're doing biology research, that's not going to work for an H-1B. They have to have the degree that's required, or the equivalent, but the equivalencies are pretty extreme. So you have to have 3 years for every 1 year, 3 years of experience for every 1 year of education. So 12 years to get to a bachelor's degree level. Ordinarily, the main issue that employers run into for the H-1B beyond kind of these baseline requirements are the lottery system. So there's 85,000 slots for lottery subject employers each year for about 200,000 applicants per year. So the odds are not great. However, universities and affiliated nonprofits like teaching hospitals, Children's Hospital, for example, are what's called cap exempt, meaning you're not subject to that cap or that limitation or lottery. So we can pursue an H-1B for employees of the university, regardless of the type of position, as long as they're employed by the university or an affiliated nonprofit. at any time, as long as they qualify and it makes sense to do so strategically. So again, just emphasizing this exemption, this is a big deal. There aren't, beyond universities and these affiliated nonprofits, there are very few additional exemptions to the lottery system. There's no limit on the number of available H-1Bs. So not only do you not have to go through the lottery, but there's no other limitation on the number of H-1Bs. There's also no limitation on timing. So normally the cadence is you apply in April and your H-1B can start in October. That's not the case for these university cap exempt type positions. It's important to know that if an employee, say an employee transitions from F1 status to H-1B status, so they were on OPT, we changed their status to H-1B. One of the advantages of H-1B status is that employees can transition from one employer to another. So it works the same way for someone coming in to CU Denver and Anschutz Medical Campus. They can transition their H-1B fairly easily over to employment here at CU. If they have not gone through the lottery, they cannot transition to a cap subject employer. So they couldn't go into the private sector if they haven't gone through the lottery, for example. So there's actually some limitations on them, which may be viewed as negative for them, but could be viewed as positive for CU because their options to be able to go elsewhere may be a little bit more limited. And you're able to retain and keep these high quality employees. H-1B pros and cons. So some advantages, we talked about portability. What that means is they can port from one employer to another with filing a petition. Now, to file an H-1B petition usually takes between 4 to 6 weeks. Sometimes it's a little bit faster. So if you have someone who's gotten an offer and you want to transition them to H-1B and they're already in H-1B status, that could happen within maybe 3 to 4 weeks, which is fast from the immigration timeframe. I know that may sound slow from the normal onboarding timeframe, but for an immigration perspective, it's quite fast. Doesn't have to be approved. With certain steps of the green card process completed, H-1B holders can also apply for work authorization for their spouses. H-4 is the dependent of an H-1B, so that's what that's referring to there. It also eases the transition to permanent residency. It's not required to be in H-1B status in order to get a green card, but if you are in H-1B status, you'd face fewer travel limitations and barriers that way when you're pursuing the green card process. You can also, for individuals from India and China in particular, this is very important. You can, normally H-1Bs are subject to a 6-year maximum. You can get extensions beyond that 6-year maximum if you've completed certain steps in the green card for those individuals from those backlogged countries. So Indian nationals or individuals born in India, really, it's the country of birth that matters for green card purposes. You can continue to get H-1Bs for them for many years, 12, 15, 18, 20 years until they get the green card. Now, hopefully it doesn't take that long, but certainly could if major changes aren't made to the system because of the demand right now and the limitations on the number of green cards. Premium processing also is generally available for the H-1B. We'll talk more about that. Some of the disadvantages. It is tied to a specific employer. Generally speaking, they have to maintain employment in order to be in H-1B status. One of the major, you could view it as a disadvantage or something with strategic implications, that there's a prevailing wage requirement. So you have to pay H-1B workers the same as you would pay anyone else situated in the position. That's called the actual wage. That makes sense. The prevailing wage is something that is mandated by the government. And in H-1B world, it is generally kind of self-selected. We select an occupational category. We select a wage level based on the requirements for the position. And you have to pay that individual at least that wage. So if the prevailing wage is higher than what they're currently making, that could cause a concern, could cause an issue. Would prompt a discussion of what needs to happen in order to make it workable. 6-year limitation, it can be fairly costly. Lana was mentioning the J1 research scholar is usually more straightforward and less costly. That's true as compared to the H-1B. We'll talk about cost a little bit at the end, just give you ballpark numbers. If the individual is changing locations, so particularly if they're moving outside the metro area, and in COVID world, that is becoming increasingly popular for remote work, there needs to be a filing that happens. So actually there's some limitations on ability to work remotely. Doable as long as we know about it, but if it's a change to remote work, it may require some action, including another filing of an H-1B to USCIS to amend that status. And generally speaking, they have to be working to maintain their status. That can also mean that they are on approved leave. So a parental leave, for example, would still be okay. They'd be considered to be maintaining their H-1B status, but generally speaking, they have to be working. They can't be put on unpaid leave by the employer. It has to be at their request. Types of H-1Bs. So how do we transition someone into H-1B status? So first of all, change of status petitions. So this is for individuals who are in the US in another status, J1, F1, maybe H4, maybe they're here as the dependent of another H-1B, but they have the qualifications that you want. Because CU is cap exempt, we can file at any time. In this situation, when they're in a different status, they cannot begin employment until the H-1B is approved. We'll talk about premium processing, but in this situation, we usually strongly recommend premium processing. They can remain in the United States while the H-1B petition is pending, but they just can't work based on the H-1B until the H-1B is approved. So for folks here on F1 OPT that are working for CU, that's part of the reason why Amy mentioned, please make sure to let ISSS know, because that's part of what they're tracking, is at what point do we need to pursue the H-1B to avoid a gap in work authorization so that their employment can continue seamlessly. For those that are already in H-1B status, but for a different employer, the process is slightly different. It's a change of employer petition. Again, they're in the US in H-1B status. Cap exempt means we can pursue this at any time. They can begin working, the employee can begin working technically once the case is filed. So we can even use to I-9 them to verify their employment authorization. We can even use FedEx delivery confirmation. Oftentimes we wait until there's an actual receipt notice from USCIS, 2 to 3 weeks with no premium processing. Next day if we use premium processing. But they can start pretty immediately. Now, oftentimes they don't want to do that. They want to wait until the petition is approved to avoid any risk that could happen if the H-1B petition had issues. Very rare for that to happen in the university context, but it can. So it still may make sense to pursue premium processing in this situation as well, depending on the level of comfort of the individual employee candidate. And finally, for individuals who are outside the US, so you found a philosophy professor in Italy who's the bee's knees. I don't know that I've used that phrase for a long time. I don't really understand that phrase, but someone you really want, and you want them to start this fall. We would need to file an H-1B for them for what's called consular processing. That H-1B needs to be approved, and then they need to set an appointment with a consulate abroad, obtain a visa stamp from the US Department of State, like we mentioned at the beginning, and then enter using their approval notice and that visa stamp. And once they enter, they can then begin H-1B employment in the US. Right now, because of COVID-19, this gets complex. There are limitations, for this example from Italy, that person can't enter unless they get a national interest exception, because the Schengen area, Europe, is under travel limitations as a result of COVID-19. And they need to get an exception from the consulate to be able to enter, which may be possible, but it's an extra step that has to be done in order for them to be able to enter the US. Also, getting appointments right now can be difficult. So that 1 month time frame is under normal circumstances. COVID can delay that even further. All right, premium processing. Very quickly. So premium processing, USCIS processes the case in 15 calendar days. It's an additional government filing fee of $2,500, so it's quite expensive. Regular processing can take anywhere from, we've seen some in 2 months lately, but up to 6, 7, 8 months. Hasn't been that bad lately, actually, surprisingly, for H-1Bs. Sometimes USCIS has suspended premium processing, but usually it's returned pretty quickly for cap exempt employers because you often have a unique need for premium processing because you can change status for someone in F1 status, for example, at any time during the year. Is premium processing required? Not always. And that's really the question that needs to be asked. So we talked about those 3 different kinds of cases: change of status, change of employer, and consular processing outside the US. I think it's usually required for a change of status. So we're changing to H-1B from F or J. If someone's status is expiring, so we're renewing their H-1B, we can file a renewal 6 months in advance. It's coming up on expiration, it still hasn't been approved, we can upgrade to premium processing, particularly if there's a business need for travel internationally. Now, again, they get an automatic extension of 240 days past the expiration. And in most cases, they're able to get driver's licenses, renewals, and things based on that automatic extension. So just for normal extensions, there's not a strong need from the business's perspective. If there's not a strong business need, like in those examples given at the top, then it's optional. And it may not be necessary, which means that the department can choose to pay for it, or the individual can choose to pay for it. That's always an option. Normally, the individual can't pay for any other parts of the process, but this is an exception for the premium processing fee. So extending H-1B status for a current employee, oftentimes we're not going to do that with premium processing because they get that automatic extension. A driver's license usually is not an issue, but if they have a need for international travel, or they have a spouse who's on an H-4 EAD, that they're worried about the expiration of that EAD, then they may want to go ahead and file for premium processing. But that's not something that the university necessarily has to cover. And then change of employers, that may depend on a discussion with the individual. Are they comfortable coming over to work with the university without having an approval in hand? They're legally able to do so, but some may be concerned about doing so.
Stephen, there's a question in the Q&A about what is considered a unique need.
Trying to think of where that unique need comes from. I'm not sure. I don't see unique need, or I don't remember mentioning unique need. Is there some clarification on what unique need is being referred to? If it's talking about what the need is for premium processing, that just kind of depends on the individual situation.
Lindsay, do you want to ask your question? Unmute yourself. Just a second here. Let me see if I can get her.
Okay. She said that I think the current slide answers it. So if you feel comfortable with that answer, Lindsay, that's great. Let me know if you need further clarification.
Yes, no, thank you. You did. I heard you say unique need and jumped on it, but I think you answered it. So thank you.
Yeah.
Okay. Thanks, Steve.
All right, some other options beyond H-1B on the non-immigrant side. This is what we call the alphabet soup of immigration. These are the non-immigrant options. The letters are just associated with the provision of law that describes the visa type. So there's all these different kinds: Fs, Hs, Js. We're going to talk a little bit about some Os, some Es, and some TNs that are also options, just briefly so you're aware. So treaty-based statuses, these are for people from specific countries only. 5 countries to remember. Here's all the flags: Canada, Mexico, Chile, Singapore, and Australia. So those are the 5 countries that have treaties with the US that provide specific visa statuses for nationals of those countries. So the TN is very commonly used for Canadians and Mexicans. There's a whole category for university teachers. So any teaching position, faculty position could get a TN, and it's usually cheaper, more cost effective, and easier than an H-1B. Not always, but it's a very good option. Canadians in particular can just apply at the border. They don't even have to get a visa stamp at the US consulate like a Mexican individual would. There's also a research assistant category, which is only available to universities, and that really applies for postdocs. This is a great category for postdocs. Doesn't use up their H-1B time. If ultimately you would want to transition them to H-1B, it can be authorized in up to 3-year increments. There's no limitation on the number of renewals you can get, though, having a TN for 12 years, they may start to get questioned about whether it's really temporary in nature. So there is, practically speaking, some kind of limitation, but not from a legal perspective. For H-1B1s, this is available in 1-year increments. You can also apply directly at the consulate. This is for Chileans and Singaporeans. It's the same standard as an H-1B. So it has the specialty occupation requirement, it has the prevailing wage requirement, but it's 1-year increments, and there is a limit, but it's never been reached. So it's as if there is no limit. Same thing basically for E3s. Same standard as H-1B, same requirements as H-1B, authorized in 2-year increments, and this is for Australian nationals. So if you see one of those countries, understand that there may be another option besides H-1B that makes sense for them for non-immigrant status. 01, individuals of extraordinary ability. This is an option that may be pushed on you by individual employees because they think they want to be seen as extraordinary, particularly researchers. It's going to be pretty rare to recommend to pursue an 01. Some examples could be, a very senior physician that doesn't have the necessary licensure, ECFMG, USMLE tests to prove their licensure in the US. An 01 may make sense. There's also an H-1B category specifically for that situation. It may be an individual where you've got a J1 scholar who's not able to get a waiver of the 2-year home residence requirement or can't get the waiver in time by the end of their J1 scholar time. Pursuing an 01 might make sense for an individual in that situation. This is a very documentation heavy and time intensive process. Here's the list of criterion they have to meet. They have to get a whole bunch of recommender letters. It's much more expensive than the other options. So this is an exceptional option, but can be pursued in certain cases. All right, you're now experts on non-immigrant statuses and options. We're going to give you the quickest primer ever on green cards. So please feel free to ask questions as we go. 3 major routes to a green card: family-based, a relationship, particularly marriage, son or daughter, of course, child or parent of a US citizen or permanent resident may be able to pursue a green card through their family. Employment-based is what we're going to talk about here. There's also a diversity lottery that people from countries that have a lower number of green card recipients are able to apply for. It's a lottery that happens each year. They can pursue that really on their own. They don't need legal assistance or certainly any help from the university to do that. EB means employment-based. So the employment-based green card process, usually a 3-step process. First, with the Department of Labor, the labor certification. Second, an immigrant petition to USCIS. Some will start here. We'll talk about those. And then finally, the adjustment of status. This is the individual process where they submit applications for relating to all their individual history, birth certificates, marriage certificates, all that kind of stuff. And that is usually not, the university isn't involved in that final step of the process. The individual is responsible for it, generally speaking, for paying for it, and ISSS has no involvement in that process. So the individual can work with outside counsel, they can find their own counsel for that final step. This is a useful chart. If you're trying to remember what the options are and what the differences are between these options, this is something good to go back to, maybe even print out and keep if you're having to look at these options on a regular basis. So we've got 5 basic options here. Outstanding researcher, employment-based first preference, extraordinary ability, EB1, EB2, special handling, which is a labor certification process for teaching positions, EB2, basic labor certification, which is most common for non-faculty positions, and then a national interest waiver, EB2 national interest waiver. We're going to talk through these a little bit, but some of the major differences for a teaching position, the most advantageous route to pursue is a special handling labor certification within 18 months from the date of the signed offer. So if it's a teaching position, that's the easiest, cheapest, most straightforward route. For individuals from India and China, they may want to pursue that EB1 outstanding professor researcher if they have the qualifications for it, because the different employment-based categories would get them a green card faster. They wouldn't be subject, an Indian national could get a green card in 2 years as opposed to 10 years. Is the difference between EB1 and EB2. So different processing times, different strategies, not going to go into the details there, but that's a useful chart to cross compare. EB1 outstanding professors and researchers, again, folks from India and China are this is particularly advantageous for those individuals because of the green card backlogs that exist. Can be applied for other people as well, but it requires a strong showing, particularly of research accomplishment. So they need to be recognized internationally as outstanding in the field. They need to have 3 years of teaching or research experience in the field. And it needs to be a tenure or tenure track teaching position or permanent research position. They have to meet 2 of these 6 criterion in order to kind of meet an initial threshold. Having the name of CU Denver behind them makes a big difference. And we have a strong record of success in these types of petitions, but we're also not going to recommend or pursue a case that isn't a workable case because the reputation of the institution is also in some respects at stake. National interest waiver. This is a much broader kind of conception. So let's say a physician that's an incredible clinician doesn't have a straightforward PERM-based process for whatever reason. We could pursue a national interest waiver for them and argue, they're not going to have a lot of research, they're not going to have a lot of publications, which is what a lot of those criterion push for. But if they're a surgeon that's pioneering new techniques or just makes a big difference for CU in their fight against COVID-19 or whatever it is, their endeavor has to have substantial merit and national importance. They have to be well positioned to advance that endeavor based on their background and their credentials. And then it's beneficial to waive the job offer and labor certification requirements. This is a position that the basic requirements don't really differentiate what this person is doing for the university in reality, for example. There are also some options that people can pursue on their own. So they may want to pursue a national interest waiver without university sponsorship. They can certainly do that. They can also pursue an EB1 extraordinary ability visa, which is similar to the O1 that we talked about, but a little bit higher standard. And that doesn't require university sponsorship. So they may be pursuing these on their own and don't really require university sponsorship or feedback. You may not even know that they're pursuing it, in fact. PERM labor certification, 2 possibilities: special handling for teaching positions, classroom teaching. Clinical instruction by itself without a classroom component is usually not sufficient. It has to be a classroom component. And then basic is non-teaching positions. So IT folks, those kinds of positions. Labor certification is the process by which you're testing the labor market. For basic labor certification, it's a pretty high standard. There's no available minimally qualified US workers ready and willing to accept the position. For special handling, one of the advantages is it's a lower standard. You only have to show that you picked the most qualified, which is the normal recruitment practice, right? So if you've already hired this person, you've already determined they're the most qualified. So you've basically met the standard already. For basic labor certification, usually we have to do recruitment again. For special handling, we only have to do recruitment again if we're past that 18-month window from the initial date of the offer acceptance. Once we get through this process, the I-140 proceeds, but it's basically at that point of a rubber stamp. USCIS is going to approve that. This is a lot of information. We talked through this a little bit, comparison between basic and special handling, right? Different timelines, special handling is faster, lower standard, only for teaching positions. The main thing to keep in mind there is it may be worth a discussion pretty soon after hiring someone in a teaching position about whether they would qualify for this special handling. Because the biggest issue with these special handling cases is that we just miss that window because it comes up pretty fast. With an offer in January for a start date in the fall, you may need to start within a couple of months of start if you're comfortable with that to try and get in that 18-month window, for example. All right, what are your responsibilities in this process? Generally speaking, the department is responsible for all fees related to the status requested for the employee being sponsored. Dependent costs, so for spouse and children, they're usually paid by the sponsored employee unless the department decides they want to pay for those costs. And we would bill the individuals independently for that, unless the department says, no, we want to pay for it. We talked about premium fees, often paid by the department, but they can be paid by the individual when it's not a case that requires it. The department must coordinate with ISSS and outside counsel to complete required actions as needed. So providing employment details, responding to RFEs. As far as initiating a case, you need to look at the ISSS website that provides instructions for how you request to even start a case and be connected to outside counsel. But after the case has been started, there may be additional steps that you need to be involved in. In the PERM labor certification, for example, involvement in recruitment is very important. Also, critically, the department is responsible for notifying ISSS, and if you have an actively open case with outside counsel, notifying outside counsel of any changes to employment prior to those changes happening. Generally speaking, standard inline promotions and wage increases aren't a big deal, but it's always better to say, hey, this is going to happen, is this okay? And just get the sign off from an immigration perspective than to find out later, we probably should have filed an amendment, and now you've put this person at risk. If changes are made that require an amendment, the department is also responsible for those costs. Very briefly, again, this is something that you can refer back if you want to look at these costs more closely. These are Ogletree specific costs. It's kind of a combination of the government fees and what the current legal fees are for Ogletree. Of course, this is all subject to change. Different outside counsel may have different costs, but this gives you at least a ballpark idea of what it looks like. We talked about H-1B, prevailing wage requirements. That's one thing that we're going to confirm, and if there are issues, we'll talk with you about. U.S. government filing fees depend wildly depending on the type of petition, anywhere from $400 up to $2,500, or not including premium processing, which is $2,500 by itself. Return transportation. If you terminate an H-1B employee, if they leave voluntarily, they go to a different job, this isn't a requirement. But if you terminate that individual, you have to offer them return transportation to their home country. They can choose not to accept it, and then you don't have to pay it, but you have to offer that. All right. I'm overwhelming you with information. We're going to talk about COVID-19 just very briefly. But any questions that you have, please feel free to put those in the chat or unmute and ask those questions. Travel, of course, is much more complicated. Country-specific limitations: South Africa, Schengen area, Iran, Brazil, China, UK, Ireland. There are some exceptions already in place for travel from those places for students, J1 scholars, maybe a little bit trickier. There's also currently a non-immigrant visa ban in place for new H-1Bs through March 31st. Not clear if that's going to be extended. And then just getting a visa appointment is difficult right now. So any travel that your employees are planning to engage in, it's always best to check in with ISSS, and they'll involve legal counsel as necessary to help advise. Then really most things have just slowed down. We talked about premium processing, the situations that need that. H-1B adjudications are maybe 2 to 6 months, so they haven't slowed down too much actually, but H-4s for their dependents are much slower, 9, 10, 11 months. PERM has slowed down from an overall timing of maybe 10 months to about 16 months with all the processing time slowed down. So those are the major impacts of COVID-19 as of now in the immigration realm. We are at time. This was a lot of information to provide to you. I'm happy to stick around if you're wanting to stick around and ask questions. But Amy or Lana, anything else that you wanted to add?
Nothing from me, Stephen. Yeah, thank you so much. This is definitely a lot of material, and we anticipate that people may have questions. So I would encourage you to reach out to myself or to Lana, or to even Stephen directly if you have any questions that you'd like to ask. Any cases that we would need to send to Stephen would be routed through us, of course, and we have our website with our processes and for the requests and everything there. So we will put our website in the chat for anyone who isn't familiar with it, but we encourage everyone to go there first to kind of find our general information, and then feel free to reach out to us with additional questions. Lana, anything else you would share?
I would just like to thank everybody for attending, and I can send the copy of this presentation to everybody just to make sure that you have reference, because we understand that that was a lot of information. So we would like you to have it. And then after you review it, if you have any other questions or you need to follow up, please feel free to reach out to us too. Thank you, Stephen.
Yeah, we ran out of time for the post-presentation quiz, but we can do that at a later time if people want to. No, just kidding.
Well, thank you again, Stephen, for all of your time and presenting all of this information to everyone. And yeah, feel free to contact us with questions. Thank you, and have a good day.
Thank you all.
Mm-hmm. Lana, do you want to stop the recording?